All right, check, check, 1, 2. Is this thing on? Pause that. Check all my monitors. Can you guys hear me? dances. Thanks for the dancing. I appreciate the dancing. So today we're here to talk about Prenda Law, now infamous copyright troll. I kind of saw all this stuff coming a couple years ago, but I was powerless to stop it myself. It turns out there were other attorneys along the way who also got the chance, and a few of them were successful. So I thought we would talk about them today. Let me see if yay, my browser is working. OBS doesn't always like the browser, and sometimes we have some hiccups. So this was the headline on December 16th that Prenda Law copyright trolls Steele and Hansmeier were arrested. Why wasn't Paul Duffy arrested? Because he died. He died, a year and a half ago. I'm not going to speculate about the dead, but I don't think that he was in the best of health with all of this going on. So Prenda Law is basically the very definition, I was going to do this the right way, the very definition of a copyright troll. They back up a second. The state of copyright trolling in 2010, 2011, 2012, a couple years ago, was that the music and movie industry had established some precedent, some case precedent, and they could have basically carte blanche. They could have their way with the American legal system as long as they followed some rules which they themselves helped establish. You could sue for file sharing, copyright infringement, and you could get results. I don't know why I'm talking with my hands. You can't see my hands. But you would sue for copyright infringement and get results. They started with the movie industry, started with the Expendables, and I don't remember off the top of my head where the music industry was at that time. But the point was that Prenda, or rather some lawyers named John Steele and Paul Duffy and Paul Hansmeier, saw an opportunity to exploit this sort of system. The way it's supposed to work, now I'm not saying that I agree with this and I'm not saying that you agree with this, but the way copyright infringement litigation is supposed to work is a plaintiff identifies, well, let's back up from there. First, a plaintiff has to create a genuine copyrighted article. Now, copyright under Article 1, Section 8 of the Constitution is for the furtherance of the useful arts. To promote the sciences and the useful arts, Congress has the power to make things like patent law, copyright law, etc. So copyright on its face has to further the copyright interest. So that means that you basically have to create a genuine copyrighted article. How easy is that? That's real easy. I'm making one right now. You can go write down some thoughts on a piece of paper. That's your copyrighted article. Anytime you fix something in a tangible medium of expression, I know those are complicated lawyer words, but as long as you write something down or fix it in some way and it can be sent or transferred in some way, understood, and usually replayed as well in that medium, or reread, etc. It's fixed. It's reusable. Usually, that doesn't mean it doesn't exist if it's not reusable. But then it's copyrighted. So you have to create something. So right there, you have a problem if you don't create something for the purposes of creation, but rather for some other purpose, like to exploit copyright law. Where are we? The Prenda Law copyright trolls saw this as an opportunity to create a copyright claim. Once you see infringement happening on the internet or whatever, then the next step is to try and figure out how to go after that person. And so that was another step that they had to overcome. But that was the step that was overcome by the music and movie industries, who set some of the stage with some of the legal precedent. So fast forward to December 16th, and these people who had been committing these acts of not committing the acts, but filing suit over these alleged acts of copyright infringement were arrested. And so I thought today we would go over how we got here, how we got to Prenda Law, and two of the three masterminds behind this getting arrested. Of course, like I said, Paul Duffy has passed. So back in 2011, lawyers like myself started getting letters, demand letters, which is normal, or rather, I didn't get the demand letters, but we got clients who got demand letters from various companies that purported to have seen copyright infringement happening on the internet, and they were suing, or they were claiming to be ready to sue over it, and they claimed to want thousands of dollars in attorney's fees, but there were problems with the litigation. For example, I received a client. I have permission to talk about some of this stuff. I'm not going to go into anybody's confidential information or anything, but I've received I received multiple clients actually, who were in my jurisdiction in Pennsylvania, but they were receiving notice of litigation in the form of a subpoena coming from Illinois or some other jurisdiction. And at first, I was a young attorney trying to figure out how in the world can this happen? This can't possibly be right. Maybe there's something I don't know. So I started to look into it, and my naive self, one of the first things that I did was I called. I forget if it was John Steele or Paul Hansel. I think it was John Steele I spoke to. Might have been Paul Duffy. I don't remember. But I spoke to one of them, and it was I was told in no uncertain terms exactly where to go and what to do with myself. And all I had asked for was a copy of a document, because I had a client in the case that wanted to know their legal options. So they weren't the nicest of attorneys. So already we have some red flags. And from there, I basically made a career out of trying to figure out how to handle some of these copyright trolls and copyright plaintiffs who maybe don't meet the legal definition of a troll. The basic difference is that genuineness of copyright. A copyright troll usually doesn't have a genuine copyright to sue over. Righthaven, I think it was Righthaven, was a copyright troll that purchased the rights to articles, news articles online. Did not purchase all of the rights to the news article, and sometimes purchased only the rights to sue, sometimes purchased all the rights but just to sue, and then would go after anyone who had reposted all or part of the news article. That was eventually shut down as copyright trolling. On the reverse side, you have some copyright plaintiffs who are still major or not so major movie producers or music producers or video game producers or software producers that do sue successfully every day over this kind of copyright infringement. And unfortunately, this case isn't going to shut that down. If anything, this case is going to make that a little bit more clear as to where the lines are and give defense attorneys and plaintiffs' attorneys alike more for our speech when we talk to incoming clients about what you can and cannot do in these cases. And then Prenda, so there were a number of really good things that came out of these cases. Not the least of which was a number of kind of hotshot attorneys who were able to step in and challenge some of these cases that Prenda Law brought. A lot of cases were not challenged because people lack resources or people lack the willpower. Let's. I thought I would share two of these documents with you today, because we're going to be here for hours if we don't. There we go. First, well, we have two we can look at. I want to look at the indictment, which would be the charges, not because the actual list of charges itself is what's interesting, but because of all the overview and text and background and stuff that's part of that. But first, I thought I would start with one of the most unique court opinions that I've ever seen. This is Judge Otis Wright out of California. Let's see if I can bring this up. This is one of the cases in which Prenda was challenged. Actually, back up. I have one thing I do want to show you first. This is why I don't like doing live streams. Nope, that's not it. Let's try this one. First off, here's a quick video. I think I can share this whole video. This is for educational purposes. Here we have, what we're going to see is three attorneys. Morgan Peets, who is one of our heroes who helped take down Prenda Law. Mark Randazza, who we might talk about a little bit more. I'll be nice to him and I might not go into all the details. And Ken White of Pope Hat. Let's see if this plays.
What's a copyright troll? And recent law review. Status-based definition of copyright troll is difficult. I don't really like the term.
Well, apparently we're having some sound issues. That was showing up on my monitor as coming through, so I apologize if that was too quiet. Again, basically the lead up that I'm trying to get through to everyone here is that these people are true copyright trolls. And so after a legal challenge in California, we got a new court opinion. And this new court opinion was written very uniquely by Judge Otis Wright. I thought you might yeah, my sound's back up now, right, guys? I've got the microphone back on. Is that working? Okay, well, someone will tell me if I'm not. It's showing up on my monitor. So back to here. The titles of the cases don't matter too much. The plaintiffs were various different plaintiffs that were concocted by Prenda Law. But this particular opinion, for whatever reason, Judge Otis Wright chose to write it in the style of Star Trek. And so it became known as the Star Trek opinion. You can still find it, well, you can sort of find it by searching for that, but of course you're going to find lots of actual Star Trek movie opinions. Plaintiffs have outmaneuvered the legal system. They've discovered the nexus of antiquated copyright laws, paralyzing social stigma, and unaffordable defense costs. And they exploit this anomaly by accusing individuals of illegally downloading a single pornographic video. Then they offer to settle for a sum calculated to be just below the cost of a bare-bones defense. For these individuals, resistance is futile. Most reluctantly pay rather than have their names associated with illegally downloading porn. So now, copyright laws originally designed to compensate starving artists allow starving attorneys in this electronic media era to plunder the citizenry. Plaintiffs do have a right to assert their intellectual property rights so long as they do it right, but plaintiffs' filing of cases using the same boilerplate complaint against dozens of defendants raised the court's alert. And when the court realized plaintiffs engaged their cloak of shell companies and fraud, the court went to battle stations. So this is a real interesting opinion here. The court talks about how their attorney was defrauding the court. He's just a red shirt. Here's a list of various different companies and people that were involved. Livewire, Paul Hansmeier, Steele Hansmeier, LLC. Court goes over how they have the power to hold parties in contempt if they disobey court orders or violate legal standards. Believe it or not, there are standards for legal conduct. Steele, Hansmeier, and Duffy are attorneys with shattered law practices. Seeking easy money, they conspired to operate this enterprise and formed the AF Holdings and Ingenuity 13 companies for the sole purpose of litigating copyright infringement lawsuits. They created these entities to shield the principals, the owners of the companies, from liability and to give the appearance of legitimacy. They have no assets other than several copyrights to pornographic movies. The copyright enforcement crusade started in 2010. Their litigation strategy consisted of monitoring BitTorrent download activity with their copyrighted pornographic movies, recording IP addresses, and filing suit, and asking for approximately $4,000. This strategy was highly successful because of statutory copyright damages, the pornographic subject matter, and the high cost of litigation. I don't know if they go into it here, but one of the things I remember them doing was putting a list of defendants' names along with a list of their alleged infringing titles of these adult movies on the Prenda Law website or another website that would it would help coerce people to want to get that taken down. For defendants that refused to settle, the principals engaged in vexatious litigation designed to coerce settlement. These lawsuits were filed using boilerplate complaints based on a modicum of evidence calculated to maximize settlement profits by minimizing costs and efforts. The principals have shown little desire to proceed with lawsuit when faced with a determined defendant. That was another very important point. There were lots of defendants who were not prepared to go to court. People have jobs. People don't have a lot of money. Even when I offer to do these cases for a very low amount of money, people still were not able to sometimes come up with the funds required to fight a case that could be a large copyright case. When faced with even a single copyright infringement or claim for infringement, you got federal law, it's copyright law, it's got lots of interested attorneys who are willing to prosecute or defend, but they want to get paid for their time. And so the defendants are often not in a great mood for litigating, and that is an advantage that John Steele and Paul Hansmeier and Paul Duffy took advantage of. They hired local counsel, and then local counsel would make various settlements and or various threats in various ways to try and coerce settlements out of defendants. Then we get to this part, which is just, this is the unbelievable part. Okay, so all that's bad enough. They stole the identity of Alan Cooper. Let's not show his address any more than I need to. They used his signature without authorization, claiming him to be an officer of one of the companies. Alan Cooper was John Steele's gardener and had no knowledge or understanding of copyrights or producing movies or litigating over them. And if I recall this testimony correctly, Cooper said that he had been asked to sign something and he didn't know what he was signing, and there may have been like another paper underneath, or he may have signed a second paper instead of the top copy or something. And this was the way that someone, I think it was John Steele, acquired his signature. Plaintiffs have demonstrated their willingness to deceive this court, not just this court, but other courts. We're getting limited with the Star Trek references here, Judge Otis, right? Let me see if we can get to the good stuff. Various things that, so here we go. One of their attorneys said that a defendant, I think, has a very large estate, and he does not, in fact. Lies to the court are not good. Attorneys are not supposed to be caught lying to the court. Certainly, there are lots of attorneys who will do their best to stretch or bend the truth as far as they can within the court's acceptance, but they might not actually overtly lie. Obfuscated facts. Oh, hey, anybody want to know what they look like? This is a great diagram. These are the guys. John Steele, Paul Duffy, and Brett Gibb. Paul Duffy, like I said, he passed. Paul Hansmeyer's a younger guy. I think he's in his mid-30s. And they created a rather large number of either fictitious or non-fictitious companies that were solely purposed for suing for copyright infringement. So this was just a hearing. This opinion that we're looking at from Judge Otis Wright was just a hearing on damages, on sanctions, damages for sanctions for having presented these lies to the court. And so the court awards attorney's fees to the defendant, compensates them for their expenses in the vexatious lawsuit. There were 2 attorneys that have appeared. Morgan Peets was one of the attorneys that was instrumental. I'm assuming Nick Granallo was as well. I don't know them personally, but I have watched their appeals videos on I think they watched one of them live even. I have one of those videos up for you, but it's incredibly boring, so I'm not sure how well that's going to go over. Yes, I dropped a hat. So the attorney's fees award was $40,000 for Peets' attorney's fees. So I think he did most of the work. The court doubled it as a punitive measure. I believe there was an appeal, and yeah, you know what? This would be a good time to cut to that appeal. There is little doubt that Steele, Hansmeyer, Duffy, Gibbs suffer from some form of moral turpitude, unbecoming of an officer of the court. To this end, the court will refer them to their respective state and federal bars. Third, the plaintiffs boldly probe the outskirts of law. Oh yeah, this is the good paragraph. Though the plaintiffs boldly probe the outskirts of law, the only enterprise they resemble is RICO. The federal agency 11 decks up is familiar with their prime directive and will gladly refit them for their next voyage. The court will refer this matter to the United States Attorney for the Central District of California. They will also refer this matter to the court will also refer this matter to the Criminal Investigation Division of the Internal Revenue Service and will notify all judges before whom these attorneys have pending cases. For the sake of completeness, the court requests Peets to assist by filing a report within 14 days containing contact information for every state and federal bar where these attorneys are admitted to practice and every judge before whom these attorneys have pending cases. And that's all that Judge Otis Wright wrote. So I do want to take a look. This is not Judge Otis Wright. This is the Ninth Circuit Court of Appeals. And no, I have no idea if this audio is going to come through. Yeah, it's very, very quiet. I don't think I can turn up the audio much.
There's thousands of
And I don't know how well you can see this, but this is their attorney.
someone that's
I forget his name.
who is a computer
It's not listed here.
genius, I suppose.
I do remember watching this live, though, and I remember that he was not a very happy attorney. You might be able to see the look on his face as he's being slowly and painfully scolded by 91-year-old Judge Pregerson.
Then comes into court and asks
It's not a fun thing to do. It's not a fun time to be in the courtroom when you're getting scolded. Let's see if I can put this back now.
Request for discovery is granted.
Okay, no. My handles go away.
And then they get they
There we go.
contact the
I'm sure that's fun to watch.
like Verizon and some of the
So we already thought that Prenda Law was pretty much on the chopping block. This was back in 2013, 14, 15 that all that part happened. So then when news came that they had finally been arrested on December 16th, that was definitely something that I thought would be worth talking about. So this, I'll take a few, I'll be a little bit slower with this because this is really the meat and the potatoes of the thing. And this is the part that I'll probably cut up and put onto YouTube as a much shorter video. So here is their indictment. As I said, Paul Duffy has passed, so he won't be indicted. But you can imagine that he would be just as much part of this as if he was. Between 2011 and 2014, defendants Hansmeier and Steele orchestrated an elaborate scheme to fraudulently obtain millions of dollars in copyright lawsuit settlements by deceiving state and federal courts throughout the country. In order to carry out this scheme, the defendants used sham entities to obtain copyrights to pornographic movies, some of which they filmed themselves, and then uploaded those movies to file-sharing websites in order to lure people to download the movies. To learn the identities of the people caught in the trap they constructed, they filed specious copyright infringement lawsuits and fraudulently procured permission from courts to send subpoenas to internet service providers for subscriber information associated with the IP addresses used. I'm going to pause right there for a second and add one more piece of information that I'm not sure if they're going to cover. I haven't read through all of this yet. I skimmed it in preparation, but wow, it's long. They also made Computer Fraud and Abuse Act claims. There is a criminal law called the Computer Fraud and Abuse Act, and that criminal law allows. It has a civil component. If you think someone is guilty of a Computer Fraud and Abuse Act claim, you can file a civil case bringing the same kind of charge or claim, but civilly for damages as opposed to a criminal charge. So, after receiving the identifying information, the defendants, through extortionate letters and phone calls, I remember some of them, they would claim to be able to take your house and basically end your financial future. It was that, which is actually not allowed. You're not allowed to make overly unreasonable threats like that. Threaten the subscribers with enormous penalties and public embarrassment unless the subscribers agreed to pay a settlement, all while concealing their collusion in the alleged copyright infringement. When courts restricted their ability to sue multiple individuals, they shifted tactics. They filed lawsuits falsely alleging, there we go. So they were originally filing these mass John Doe lawsuits. One case might contain anywhere between 10 and 20 and hundreds of defendants. I want to say the largest number was in the thousands. I don't remember if that particular case was Prenda Law or not, but that's what they would do is file a case with multiple defendants. Well, they only paid one $400 fee, so the courts didn't like that a whole lot. Finally, when the courts became suspicious of the defendants' tactics and motives, the defendants began a long process of lies and deceit. In total, the defendants obtained approximately $6 million made possible by fraudulent copyright lawsuits. Under both Minnesota and Illinois rules of professional conduct governing attorneys, they owed a duty of candor to the court not to make false statements or cause false statements to be made to any court, and to correct any false statements that had already been made. In an ex parte proceeding, where only one of the parties to the lawsuit are communicating with a judge, they were obliged to advise the court of all material facts, whether or not the facts were adverse to their position. In a lawsuit, parties generally participate in a discovery process where they are able to obtain potentially relevant information and documents from the opposing party as well as third parties. Under certain circumstances, a party to a lawsuit may be able to obtain early discovery before it would normally be available to the party through an ex parte proceeding in order to obtain evidence to allow the lawsuit to proceed. If evidence is in the possession of the third party, etc., etc. They're talking about these the process in which you get the defendant's identity. When you want to sue someone but you only have an IP address or a license plate number, you can file a John Doe lawsuit against the IP address or the license plate number and request a court order granting you access to the identity from whatever agency or entity has it. In this case, the ISP. So you can imagine the internet service providers didn't want to be involved with these cases either. They tracked everything through BitTorrent, including through Pirate Bay. BitTorrent makes your IP address publicly available as it downloads, so they just track that in a forensically sound way or not. They should be prepared to present it in court then later. They talk a little bit about how BitTorrent works. There's an initial uploader or seeder, sometimes more than one, who begin the upload by making the identical file available. Steele Hansmeier created various law firms, Steele Hansmeier, something else, Prenda Law, the Anti-Piracy Law Group, a couple witnesses, ML and PH, computer forensic consultant, Guava Livewire Systems. More companies created sham clients that purportedly own copyrights to pornographic movies or operated computer systems associated with pornographic movies. Count 1. Conspiracy to commit mail fraud and wire fraud. Beginning no later than in or about 2011, and continuing until at least 2014. In Minnesota and elsewhere, the defendants did knowingly conspire with each other to devise and participate in a scheme and artifice to defraud and obtain money and property by means of materially false and fraudulent pretenses, representations, promises, etc. Cause the sending and delivering of things by the U.S. Postal Service, cause a transmission in interstate commerce of wire communications, specifically executed a scheme to fraudulently obtain millions of dollars in copyright lawsuit settlements by deceiving state and federal courts throughout the country. The lawyers used sham entities they controlled to obtain copyrights to pornographic movies, some of which they filmed themselves. The defendants then uploaded the movies to file-sharing websites, hoping to lure people into downloading them. After coercing courts into giving them the power to subpoena internet service providers, the defendants used extortionate tactics to garner quick settlements from individuals who were unaware of the defendants' role in uploading the movie, and often were either too embarrassed or could not afford to defend themselves. When these individuals did fight back, the defendants dismissed the lawsuits rather than being at risk of being unearthed, having their scheme unearthed. After courts began limiting the number of people that they could sue, they changed tactics and claimed that they had been hacked. Usually this was because of password sharing. They would say that someone had shared passwords, and that constituted a violation of the Computer Fraud and Abuse Act. And it goes into some history. They began representing entities that owned copyrights in 2010. They filed copyright infringement lawsuits against anonymous individuals, sometimes referred to as John Does, and sought early discovery, yada yada yada. Copyright statutory damages permit plaintiffs to recover up to $150,000 per infringement, and they sought settlements of approximately $4,000. Beginning in or about April 2011, defendants caused their investigator to upload their pornographic movies to BitTorrent, including to the Pirate Bay, in order to entice people to download the movies and make it easier to catch those who attempted to obtain their movies. As defendants knew, the BitTorrent websites to which they uploaded their clients' movies were specifically designed to allow users to share files, including movies, without paying any fees to the copyright holders. Thus, defendants knowingly caused their clients' movies to be shared and distributed on BitTorrent websites, and therefore purposely allowed and authorized the BitTorrent users to obtain their clients' movies. Thereafter, despite colluding in the purported copyright infringement of their clients' copyrights, they caused lawsuits to be filed disingenuously, allowing the individuals who purportedly downloaded the movie did so without authorization or consent. For example, PH uploaded a movie which was owned by a client of the defendants named Heartbreaker Productions. After catching approximately 71 IP addresses engaged in the downloading of the movie, which defendants had caused to be uploaded, defendants filed a lawsuit in federal court in Illinois on behalf of Heartbreaker Productions, misleadingly alleging that the 71 John Does had downloaded the movie without authorization. Then they filed an ex parte motion. Remember we said ex parte required a higher standard to the court? They filed an ex parte motion seeking the pre-Rule 26 subpoenas for the identities from the ISPs. They caused at least 200 copyright infringement lawsuits to be filed in courts throughout the country, seeking more than 3,000 IP address identities. After receiving the subscriber information, employed the same tactics in order to garner quick settlements. Defendants falsely represented to the subscribers and their clients that their clients had legitimate copyright infringement claims. By lying to the courts in order to obtain subscriber information and deceiving the subscribers, defendants fraudulently obtained numerous settlement payments. Defendants then obscured their involvement in the scheme. In November of 2011, defendants caused Prenda Law to be created. Yet they, on multiple occasions, falsely denied to various courts any direct involvement or control with Prenda Law. Defendants at times used the name Anti-Piracy Law Group. They created more entities: AF Holdings, Guava, Livewire, and LW Systems. Defendants represented and caused to be represented to multiple courts that AF Holdings was owned by a trust named Saltmarsh, whose manager and sole beneficiary was ML, the paralegal employed by Hansmeier and Steele. She was nothing more than a figurehead who agreed to pose as the owner of AF Holdings in order to help them obscure their ownership and control over the companies. Defendants caused Ingenuity 13 to be formed, and Guava, and Livewire, and LW Systems. In May 2012, defendants filmed and caused to be filmed pornographic movies in order to further their scheme on at least 3 separate occasions while attending film conventions. They contracted with adult film actresses and produced multiple short pornographic films. Hansmeier and Steele caused Ingenuity 13 to obtain copyrights to the films. They did not publicly distribute or commercially release the movies. Instead, they uploaded them to file-sharing websites and then threatened to sue. It's the exact definition of a copyright troll, guys. Jeez. When the defendants caught multiple people downloading their movies, they then caused fraudulent copyright infringement lawsuits. Yeah, we can go over that. Caused false representations to the court. In October of 2012, courts began limiting discovery. Yeah, this is I remember this. I got some Guava defendants, and they started making computer fraud accusations. The entirety of defendants' hacking lawsuit was a lie. In fact, Guava had no computer systems. They were sham entities controlled by defendants for the single purpose of obtaining lawsuit settlements. Did the same thing with Guava, early discovery. Upon uncovering certain facts, courts began denying the defendants' requests to subpoena ISPs, dismissing lawsuits, etc., etc., etc. And then here we have a quote from Judge Otis Wright. Plaintiffs have demonstrated their willingness to deceive not just this court, but other courts in which they have appeared. Doesn't this sound familiar? I think we actually read that quote ourselves. During another hearing, ML falsely and misleadingly testified under oath that he did not know PD when in fact he did, and was attending a hearing at the request of a woman named Sunny Leone, when in fact Steele had asked ML to attend the hearing. Isn't Sunny Leone an adult entertainment actress? I don't know that. In another Guava hearing, Steele falsely and misleadingly informed the court that Guava had some computer equipment when in fact it had none. Under penalty of perjury, falsely and misleadingly represented that he was CEO of AF Holdings when in fact ML was nothing more than a figurehead. So lots and lots of false and misleading to the court. Let's see what else we've got here. Filed a complaint with the State Bar of California against BG, which I'm only assuming is Brett Gibbs, to oversee copyright litigation on an attorney hired to oversee copyright litigation where he misleadingly claimed that ML was a figurehead. Steele further falsely alleged that BG was the primary attorney for AF Holdings. Yeah, that's this was really getting deep and complicated here. signed a declaration in another case that he has never served as the director of AF Holdings, etc., etc. So they really screwed the pooch on this one. Here's more for mail fraud. And they cite several examples of specific pieces of mail. Conspiracy to commit money laundering. Conspiracy to commit and suborn perjury. Oh, we're going to go through some of them. Yes. More about saying he's not affiliated with or CEO of AF Holdings and all the other different entities he created. More things signed under declaration of perjury, under declaration of under penalty of perjury. Forfeiture. Okay, now this is interesting. For the purposes of alleging forfeitures pursuant to Title 18, okay, as a result of the offenses, any real, personal, any property, real or personal, which constitutes or is derived from the proceeds traceable, is in play. The defendants shall forfeit all property, real or personal, involved in the violation. So that means the $6 million, wherever it is, shall be forfeited, and anything that was gained from it. That could be a lot of stuff. That could be houses, that could be cars, that could be, or that could just be a bank account that still somehow says $6 million in it. Oh, and that is the whole thing. So what do you guys think? That's how those guys got arrested. They'll probably go through some form of a trial, unless they decide that it might not be a good idea to hash all that out in front of a jury, and maybe they'll make a plea agreement with a judge, or with the U.S. attorney and the judge. The plea agreement does need to be approved by the judge. They don't just automatically get whatever the U.S. attorney is offering. However, I would expect there to be a discussion at some point about a plea agreement. How much time will they spend in jail? I don't know, actually. I'm not really a criminal defense attorney, so I don't, off the top of my head, know what each of these claims and or each of these charges. Yeah, see, that's me. I'm speaking in claims, and these are charges. What each of these charges brings as far as a penalty. But I'm assuming that these are serious charges, and they're probably facing many years in jail. More than 2, more than 5, I would think. And they probably owe lots and lots of that money back. And then what about the people who did pay a settlement? Now that we have conclusive proof, what do those people do? Do they try and seek their money back? Is there any money to be had? Is the government going to get it first? And what are they going to do with it? These are all questions that need to be answered. This has been a live stream, so I appreciate you hanging in there with me and my experience at doing this kind of thing. I thought now would be a good time to open it up for questions. Let me know if there's anything I skipped or if there's anything you want to see. We'll talk about it. Otherwise, that's basically what I wanted to talk about with Prenda Law. I can't think of any terribly interesting stories that I have with them that I'm allowed to talk about. They pretty much, the way it happened to my clients. Here, let's see if I can. There we go. The way it happened to my clients was usually they would receive notice of the case. There's a couple different laws that come into play when someone subpoenas your internet service provider for your identity. One of them is the Cable TV Privacy Act of 1984, and you have the right to be notified when your account information is sought. So usually people get that letter first. Sometimes people miss that letter, or they, like, for instance, I don't open my RCN bill because I pay it online. So why should I ever need to open it? If I got a letter from RCN that said I was being sued in copyright court, I might not know. So it depends on what, hopefully they're putting this in a letter that says important legal information or something on it. I know Comcast at one time was sending things via UPS. I think they stopped that. If you missed the letter, then the next time you heard about the case was when someone filed something in court and you were notified that you're involved. So let me look over your comments here. I see there's a lot. Am I right that this case might help defeat copyright trolls in the future? Specifically trolls, yes. The problem is going to be the same, though. You have to identify the trolls. Right now, for example, there's lots of these kinds of cases that are still going on, thousands of them a year, many more than Prenda Law was ever involved with. But those cases are all not doing these advanced unethical tactics, and instead are more or less they're actual copyright producers who actually publish things who then use these same tactics to a more limited and more ethical degree. I'll stop there. Yeah, if you write down your chat, even your chat comments that you typed in there are technically your words. If you wrote something and you thought that it was valuable enough to publish it or sell it, yeah, you can go publish those words. Those are your words. Yes, Wrath of Khan. Yes, take a drink every time I change my hat. This would be a very interesting jury trial, yes. Um, it would be a very long jury trial. I think it would be weeks. They'd be presenting all of this for 2 weeks or 3 weeks, I think. I think I might try to go to that. Yeah, bites back. I'll probably have to change the color on that. Recently passed Countering Disinformation and Propaganda Act. Ooh, that's interesting. I'll have to take a look at that. Let's do this together. Oh, interesting. It just happened. Let me see if I can find a mainstream article on it. This looks like a lot of tiny journals. Oh well, we'll just try the first one. Okay, this was the part of the 2017 Defense Authorization Act. establishes a Global Engagement Center under the State Department, which coordinates efforts to recognize, understand, expose, and counter foreign and non-state propaganda and disinformation efforts aimed at undermining United States national security interests. Well, that could be anything. Jeez. Yeah, we'll have to talk about that too. Let's add that to the list. Wow. Yes, web security is a defense, but in copyright court, this is a civil court, so you don't have the beyond a reasonable doubt defense. You have to convince the judge just as much as your plaintiff or your opposing side has to convince the judge. So you'll have to bring on an expert and explain how you were protected through WEP and explain how it could be cracked and convince the judge that that's likely what was happening. All of these IP addresses that we're talking about are dynamic. Very few of these, well, then I shouldn't say all of them and then say very few, should I? Most of these are dynamic. Very few of them are static. Last time I was in court over this, the ISPs testified that they use two different computer systems to track and log who gets assigned which IP address, and if those systems don't agree, they don't respond with a positive on the identity of your account. Yes, they apparently got so desperate that they made their own porn. Now, any of you, and I'm not recommending it without a longer conversation with your attorney, but any of you could create some copyrighted content. It doesn't have to be pornography. It can be music, movies, text, videos, YouTube, whatever, and you can go post it online for sale or other controlled publication, not the Pirate Bay, and you can go file a $35 copyright registration with the U.S. Copyright Office, or you can file a copyright registration with whoever your copyright agency is in your country. Now, of course, not all of what I've been talking about will apply, but this is all in the U.S. But if someone does infringe on your copyright, then you can sue under that law in your country. In the U.S., that means all of this comes into play. As long as you're not doing the things that Prenda Law did, as long as you own the copyrights, and as long as you follow legal procedure properly, and as long as you don't overstretch or overreach with your demands and your embarrassing letters or letters alleging embarrassment to the defendant, you'll be much closer to an ethical plaintiff. So you can go and make your own copyrighted stuff and get it stolen and sue people. I don't recommend it. I think it's much more interesting to make more content, and you can issue takedowns and things for copyrights that are being infringed. I, for example, recently put up an accident video, a car collision video. One of my security cameras caught something, and it instantly got stolen and reposted to eBaum's World. And you know what? I'm not going to sue anybody over that, because it's just a car crash video. It's not getting millions of views, and it's not going to make anybody rich, and it's not worth my time. I'm not going to answer how much adult entertainers get paid. I don't know. But that sounds like it could be possible. It depends on where you're living, but yes, $500 in the US is not a lot of money. That's maybe a family's food budget for the month when they go grocery shopping. That could be about a quarter of your rent if you live in a major city. All right, guys. Some of you are signing off because you're from other parts of the world. Thank you for coming. I appreciate that. Yep, they're RICO'd. You know, I didn't actually see a RICO. Well, there was plenty of conspiracy. They don't say the words RICO, I don't think, in there. There were plenty of conspiracy allegations. So that's a good suggestion. Watermarking your videos, or how else can you protect your videos? You can protect your videos in various ways. We'll change hats on camera. There we go. You can protect your videos in various ways. One of the things that I keep saying about these copyright cases, why the heck don't they put some kind of unique watermark in each video that is released? I don't mean one. I mean, so let's say I make a video, I put it on YouTube. When Leonard French plays back that video, there should be a little overlay or something somewhere that says Leonard French. Or maybe there's a steganographic method of storing the data within the image. Look up steganography if you're interested. No, does not involve stegosauruses, but you could hide data inside a picture of a stegosaurus. There you go. But you could do some kind of unique watermark so that when I sign into my account and I download a copy of the movie legally, you know who has downloaded it. I believe Apple does this, or did this when they did DRM. Maybe they still do it with their digital downloads for iTunes. If I then went and shared my iTunes download, which I don't think had DRM. I think it was when they removed the DRM, they kept the watermarking in. If I shared my digital iTunes file, they would know who was the originator of the file. Even if I copied the audio, there was something steganographically in the audio that you'd be able to read the data back and get the unique code. And I believe there were court cases over getting this information from Apple, and who under what circumstances did you need a warrant, that sort of thing. Okay, so yeah, that's a good point. I'm not an expert with steganography. Exactly. They won't do it because they don't have to. There's no law that's requiring anyone from taking any of those appropriate measures preventing that sort of copyright infringement. But they don't take those measures. They just continue to sue. So until the U.S. Congress updates the copyright law to be more favorable to the copyright defendants, I don't know, guys. I can't say that with a straight face. I don't expect that to be happening. I wish. I believe in open information, and people should definitely reap the benefits of what they make, but we also need to encourage new innovation, so you can't just rest on your laurels and create one good thing and never create anything else again. That does work once in a while, but it's most definitely not the norm. So yeah, you can communicate information through high-pitched tones that your smartphone's microphone picks up, and who knows where they're going to go with that. So all very interesting things. I think I'm going to end there. I thank you all for watching. I really appreciate all of you coming and hanging out with me tonight. And I'm going to try and do more of these. This is my new live streaming rig. I've got my camera's HDMI output through an Elgato game capture thing and microphone and all that hooked up so that this could be semi-high quality. So we'll see how it worked, and hopefully if you guys like it, you'll continue to watch. So I'm your favorite copyright attorney. I'm Leonard French. Have a happy new year, everybody, and I will talk to you later.